I was directed your lordship to come.
Which one?
250.
This number?
Criminal appeal 1240 to 1240 of 2016.
You have filed IA for what?
Early hearing.
Early hearing, this is not the bench. Early hearing, this is not the bench.
It was observed by all.
This is not the bench. Early hearing is before the regular bench. You will hear this.
IFR bail,
You have filed the bail very recently.
yes.
This court will not sit for one bail. But you have permitted finished for the others. There are 20 cases listed, you don't have to mention. I have given instruction when there will be 20 to 25 cases, they will sit.
For all matters, under the ID for admission, serial number 29, MA number 419 of 16, Mr. Ramesh Kumar Das for appearance, Mr. Vikesh Kumar for respondent.
May I please your lordship. In this case, the insurance company is contesting the appeal only on the ground that your lordship vehicle was used for unlawful purpose and it was used for committing the murder of the deceased. It was not a natural accident. Here it is a case where the vehicle was carrying illegal coal. The victim, the deceased, was a police officer. Therefore, lordship, the vehicle is being used for an unlawful purpose, a purpose other than for which permission has been granted. Then your lordship, defense under section 149 is available to the insurance company.
What is the difference of this?
Lordship, may kindly see your lordship 149 to C, for a purpose not allowed by the permit under which vehicle is being used.
And the permit it was released.
Lordship, it is a case of deliberate murder. He says that the police officer, lordship, wanted to stop the vehicle, they deliberately ran over it. Investigation was also done, charge sheet was also submitted showing this.
The purpose of using the vehicle was not to commit.
Not to commit murder.
Not to commit.
Yes.
So you are saying that it was being used to commit murder, it is not.
Not yes.
Then why will you not take the purpose using of the vehicle, the purpose for using the vehicle was not to commit.
Purpose of using of the vehicle was to
For transport.
for
Transport be illegally transport.
illegal transportation. If suppose coal is being illegally transported, two vehicles, lordships, dash head on. Naturally, lordships, the insurance company will be called upon unless there is a violation. But your lordship, in a case where your lordship, the offence, it is being used to commit an offence, and in order to escape from being caught, it deliberately kills a person. Vehicle is being used as a weapon to kill a person, a police officer who was discharging his duty. Then it is not being used for a purpose for which.
Any judgment?
So in this case, lordship, we have to do some research. Lordship. There is no judgment against me also. And
what the claim? Lordship, this lordship has actually said this is not for the purpose of. Now when the vehicle was being stopped by the police, the driver had rashly and immediately given up the vehicle, and by that the accident is taken place. And the permit and every documents are there.
What is the judgment that murder was therefore regular?
Lordship, murder of a driver, there are judgments.
What is the judgment?
Shall be that those are in 163. It is being there.
Supreme Court said the intention has to be.
No. Supreme Court said in those cases that the vehicle, the death has been occurred out of the use of the motor vehicle. Had the driver not been driving the motor vehicle, he would not have been robbed and he would not have been murdered. Therefore, it is arising out of the use of motor vehicle.
This is also so far as you see from the side of this person who died.
No, person who died, also at best I can, if I succeed, I will get the right of recovery. Because if the owner is putting the vehicle in illegal use, lordship, the insurance company cannot be called upon to indemnify the
You
owner.
get them out.
Lordship, can I hear it finally, lordship,
No, you
next
get
week?
them out.
No, we have not paid. Lordship, keep it next week, lordship, pass the final order, lordship, in the meantime, and if it falls, ultimately.
The owner has not yet.
Owner has not yet.
Notices were issued, your lordships, on 31/8/21 itself. Most probably there must be valid service, otherwise it not.
Is the owner? Four.
4. 5 is travel.
And one more.
You should notice, request notice to the owner of the vehicle, that is respondent number 4, to officer in charge, Mangalore police station. You can file an affidavit after service of notice, the officer in charge will file an affidavit in compliance.
Serial number 34, MA number 714 of 17, Mr. Amresh Kumar, for appellant, Mr. Navdeep Sai, Mr. Akshay Kumar, Mato for the comment.
Matter into all personally drag matter, letting it behind force also. Matter, 4 kilos. And each sound in 1 lakh for slab in it. इसमें मेरे घर में नहीं कि मेजर जो नो डिवाइड ऑफ क्लेमेंट एंड मेजर क्लेमेंट एंड मेजर का जो इसमें घर में एक तेरा 15 में पेज तक तेरा 15 में पेज तक it is settled by now that the legal responsibility for the deceased have right to apply for compensation having said that it must necessarily follow that even the major merit and having songs of the deceased will gain legal representative have right to apply for compensation.
Who is disputing this? Who is disputing this proposition? He is taking only one law. That on love and affection you cannot grant 4 lakh rupees, which is against the judgment of the Constitution bench in the case of conviction.
1 lakh for loss of state rewards.
And also 1 lakh for loss of access. This total is
5 lakh.
5 lakh 25,000. 25,000 funeral expenses, 1 lakh loss of estate and 4 lakhs for love and affection. 5 lakh 25. This case is the 5 lakh 25,000.
And further you also 9% interest you
No,
also.
I will not. He is taking only this. Then कर सकता है, दे सकता है 5 लाख रुपया बढ़ जाएगा, ठीक है. Further counsel for the appellants, insurance company, and the claimants. The insurance company, appellants, has filed this appeal challenging the part of the award passed by the Motor Accidents Claim Tribunal, District Judge 4, Bokaro, in Motor Accidents Claim Case number 83 of 2014, dated 30th day of June 2017. First up. The ground to challenge the award is limited.
2 grounds, Your Lordship. 2 grounds. First, last occasion, Your Lordship had turned down, but my ground is there, Your Lordship, that the driving license is not produced by the, only number is produced, but the insurance company has not given. That's my submission.
It's limited. First. The learned counsel for the appellate, insurance company submitted that the owner of the vehicle, owner of the offending vehicle has not produced the driving license. As such, adverse inference should have been drawn against the owner. It is his contention that if adverse inference is drawn against the owner, then in view of the judgment of the Honorable Supreme Court in the case of Popko and so on and so forth, it is the owner who has to pay the amount of compensation to the claimants and not the insurance company. Since it will be deemed that there was violation of the condition of policy as the vehicle was being driven by a person who was not authorized to drive this. The second ground which has been raised by the council appearing on behalf of the applicant is that the tribunal has awarded 4,25,000 on account of 25,000 as compensation on conventional debt in place of rupees 70,000 as held by the Honorable Supreme Court in the case of Financial. Next slide. These are the only two grounds raised by the insurance company in this appeal. Next slide. Considering the limited ground which has been raised, this court feels it is not necessary to call for the lower court record, as there are sufficient material in the judgment itself to deal with the aforesaid issue. Since the factum of accident, the insurance coverage, the dependency, and the income is not disputed, I am not entering into those aforesaid issue. Next slide. The counsel for the respondent submitted that even if the claimants are major son of the deceased, they are entitled to receive compensation. Next slide. उसके बाद जो लिखते हैं, to answer the first question, I have gone through the judgments. In paragraph 5 of the judgment, the tribunal has noted that the offending vehicle was being driven by a person, by Mahesh Tiwari, Gopal Kumar Tiwari. Gopal Kumar Tiwari alias Mahesh Kumar Tiwari, who was holding the driving license bearing number JH09 of 2006 of 0008147, valid from 2006 to 19/7/2008.
जजमेंट में गलत, जजमेंट में गलत हो गया, और चूंकि ये लाइसेंस प्रोड्यूस ही नहीं किया, अपीयर होने के बाद प्रोड्यूस
license number search. As per the judgment of the Honorable Supreme Court in the case of Pappu and others versus Vinod Kumar Lamba and another, the Honorable Supreme Court held that the preliminary responsibility is upon the owner of the vehicle to state about the validity of the license. So in absence of any documents or any statement, when the owner of the vehicle discharges their liability, they discharge their owners of ownership upon the insurance company to prove the contrary. In this case, I find from the appeal order that a driving license number was produced by the owner of the vehicle. Thus, the owner has discharged his onus. Now it was upon the insurance company to come up with a positive evidence to suggest that either the aforesaid driving license is fake, forged, or was not valid at the time of accident. The insurance company admittedly in this case did not produce any evidence, thus failed to discharge their duties. In view of the aforesaid scenario, it cannot be said that adverse inference should be drawn against the driver. Rather, the adverse inference should be drawn against the insurer of the vehicle, and it should be held that the vehicle was, in absence of any evidence, the vehicle was being driven by a person having valid driving license. This issue raised by the insurance company is answered against them. The next issue which is raised is in respect of the quantum which has been assessed under has been assessed and awarded as non-pecuniary loss. In this case, admittedly from the award, I find that an amount of rupees 5,25,000 has been awarded as consolidated amount on account of funeral expenses, loss of estate, and love and affection towards the child. In this case, the deceased is aged about
67 years.
67 years. And all the claimants are aged. Though this aspect will have no bearing on quantification of the amount of compensation under convention. The Honorable Supreme Court, in the case of Pranay Shetty, National Insurance Company Limited, Pranay Shetty and others, so and so, in paragraph 59.8 has read as under. From the opposite paragraph, it is clear that an amount of 70,000 rupees was assessed to be a just amount for the purpose of grant of compensation under the convention of rates. This court, there is no doubt to hold that the tribunal has awarded an exorbitant amount under the same claim. The claimants are entitled to receive 70,000 rupees on conventional debt and not 5,25,000. Is there anything that they were dependent? There is nothing that they were dependent. But when it comes to go like that, this is was 61 and major, and they were not dependent on this. In view of what has been held above, this appeal is partly allowed. Allowed. We'll start. The amount of compensation awarded under conventional debt is reduced to rupees 70,000 in place of 5 lakh.
Your Lordship, by order dated 18/5/2018, insurance company has deposited the amount in two checks, Your Lordship, 2 lakh and 5 lakh. 2 lakh released in favor of the claimant, 5 lakh intact. It is not. It will come to the insurance.
Because the Council for Insurance Companies submits that amount of rupees 2 lakhs has been released in favor of the claimants, whereas 5 lakh rupees has been kept on board.
Yes.
Last, the insurance company is directed to take refund of rupees 5 lakhs. But the deposit from the executive court goes up. Last, the insurance company will recalculate the amount of compensation along with interest, and if it's found that some further amount is required to be paid to the claimants, the sheet will be paid to the claimants.
Statutory amount may be
The statutory amount will be refunded for the insurance.
public.
Serial number 35, MA number 730 of 70, Mr. Mohammed Jayed Ahmed for appellant, Mr. Alok.
Yes.
Lordship, this area has been filed for enhancement, Your Lordship.
Yes.
This area has been filed for enhancement.
This is area number
35.
state of the owner appearance has to be estimated because the right of recovery has been given to the owner. To the insurance company against the owner.
By an order dated 18/4/2022, it is apparent that notices have been served to respondents.
Who is the owner? Respond number?
Respondent number 1, Your Lordship.
One.
Received by father-in-law. This is for enhancements.
Your Lordship.
What from? This enhancement.
The income, future prospect and conventional head. Exhibit.
For the local report since the quantum of compensation, since the applicant has paid for enhancement of the amount of compensation on the ground that the income of the deceased has been wrongly assessed.
Other grounds are also the future prospect.
This.
Under the heading for hearing, serial number 37, MA number 41 of 50, Mr. Rajesh Kumar for appellant, Mr. Arun Kumar, Mr. Alok for respondent.
Yes.
Amount of compensation, my lord, has been awarded against the appellant before your lordship, who is the owner of the vehicle, my lord.
Applicant is the owner of the vehicle.
Vehicle.
Yes.
In this case, my lord, on 18/12/2002, my lord, the scooter of the claimant has been met with an accident with the truck of the appellant before your lordship. Now, my lord, thereafter, my lord, the appellant and respondent company has been noticed, and on notice, both were appeared, my lord, but after filing the reply, the appellant has left the case, and subsequently the order has been passed ex parte against him. Now, my lord, I would like to place page 19, my lord, for a moment of my memo of appeal. This is cover note, ma'am. Actually, what has happened in this case, that exhibit number C, exhibit C, G.
The case of injury.
Injury.
You were the owner of the offending gate.
Yes.
How much amount?
1,72,214 has been awarded along with an interest of 7.5% per annum from 4/4/2008. My lord, it has come in the impugned judgment also, my lord. Page 23 is the relevant piece.
Yes,
Yes, my lord.
yes,
This is the cover of my lord.
insurance company.
Yes.
Yes.
My lord, date is very important. My lord, it was valid from 23/11/2002
Yes.
to 22/11/2003.
Yes.
My lord, amount has been paid at 8,622. लास्ट में है जो उसी में कुल रुपए टोटल
Yes.
जहाँ डेट है उसके जस्ट नीचे में देखा जाए, जहाँ डेट नोट किए ना जहाँ से 23/11/2002 टू जो है उसके जस्ट नीचे.
Yes.
Now, my lord, all of a sudden, my lord, the cover note has been cancelled, my lord. Page 20 of my brief is there.
This is only
On
this cancel when?
it was cancelled
After 3 days.
27/11/2002.
From where are you getting this?
सबसे लास्ट में देखिए, सबसे लास्ट में मतलब में 27/11/2002 4 छोटा सा लिखा.
Because on 25/11/2002.
27/11/2002. It was issued from 23/11, but on 27/11/2002,
27 or 25?
20, as per my correct, it is 25. Let him, it is 25.
क्या है? हेलो 25 है. It may assume on 25/5th, my lord. But still it was valid for 60 days.
Covenant is valid
60 days. Perhaps my lord 142. Yes, 100.
even if it is 25 or 27. it
No,
has-
it has. Presume it at 25.
So they say it was cancelled.
It was cancelled. It was never informed to the appellant. My lord, the agent code is there. The agent is his man of insurance company. Payment has been received by Basant Kumar. I am not the Basant Kumar.
Yes. Yes.
Now, only after my lord, the vehicle was met with an accident on 18/12/2002. Then, my lord, I have approached to the insurance company, wherein my lord, I have been informed that your insurance has been cancelled. Cover note has been cancelled.
Why is that? Why is
My lord, it will reveal, my lord, that on the next day, 19/12/2002, the insurance has again been taken by the appellant.
That is one day after the accident.
After the accident. Again, it was since it has been informed that your insurance company has been cancelled, and as such, he has to take fresh insurance.
So this is the only case.
This is the only case.
Yes, Mr. Clark. How can and on what condition the cover note can be cancelled and what are the conditions?
In this case, the cover note was cancelled, premium amount was returned to the agent because he was the person who has brought the business of the insurance company for this thing. Now, please get what
So to bear with you, I have to put a question.
I'll answer it.
The agent is whose agent?
Agent acts on behalf, is the agent of the insurance company on behalf of the claimant because the policy is being issued by the insurance company business.
Just
He acts as a bridge between because certainly he is an agent of the insurance company. Now,
so he is the agent of the insurance.
insurance company, certainly because now he is the person who facilitates the insurance of the vehicle because a number of times, as we have understood and we are also doing it, we do not go to the insurance company as their normal practice. That agent comes and collects the premium and gives it to the insurance company. In this case, what had happened? This vehicle was old vehicle. Due to mistake, the calculation was made and the premium with regard to the third package policy was taken. Now, thereafter, when the insurance company came to know that because of new tariff, this policy cannot be issued, the cover note was cancelled, premium was returned.
Where is the provision for cancellation?
Now,
One, which provision?
that would be under the insurance act. I'm not going to the insurance act. Now, in this case, now I am putting a question to myself.
First, let us understand, is there any provision for cancellation?
Policy cancellation of policy is there, but I am not having the insurance act at the moment. Where was the farmer?
Get one.
Now,
So there was a calculation error and the vehicle was old.
yes, old, therefore, it could not have given the package policy.
It would have given the third
Third
party.
party. Now, in this case, what has happened? Now, I am putting a question to myself. What prevented my learned friend to appear and contest his case before the tribunal after filing written statement the 25th December? Now, thirdly, a very important question I will be putting in myself. Suppose if he was not aware of the policy which has been cancelled, under what circumstances he signed a fresh proposal and opted a second policy? Why he has not objected to it? Meaning thereby, the cancellation was well within his knowledge. Therefore, he consciously is opting the policy after the cancellation. No prudent man will sign and issue of acceptance of proposal form during the substantial survey or
Show me your document of communication.
yes, exhibit D and INDC. Exhibit D. D. Now, these things have been dealt very clearly been dealt with.
Exhibit D.
Exhibit D.
Exhibit D.
Exhibit D is addressed to the agent. I am not having. I am having the copy of the. I don't really have that. This. Yes, exhibit D is dated 25/2002. विषय वाहन संख्या CG 140239 खाता श्री विजय कुमार गुप्ता के कवर नोट निरस्त करने के संदर्भ में उपरोक्त संदर्भ में कहना है कि आपके द्वारा जमा प्रीमियम राशि 8,622 रुपए जो मात्र ट्रक संख्या 7 जमा किया गया था एवं कवर नोट संख्या 7 जारी की गई थी निरस्त कर उप प्रीमियम की राशि श्री विजय कुमार गुप्ता को सौंपने हेतु की जा रही है। उनसे कवर नोट की मूल प्रति वापस कर कार्यालय में जमा करें। कवर नोट निरस्त करने के कारण मोटर बीमा संबंधित नए प्रावधान के अनुसार व्यावसायिक वाहनों जो 5 से अधिक है मॉडल वेरिएंट वर्ष का हो उसका विधिक क्षति बीमा नहीं करना है, केवल तृतीय पक्ष दायित्व बीमा ही किया जा सकता है। उस परिपत्र के आधार पर उक्त कवर नोट संख्या 7 को निरस्त किया गया है। कृपया पावती सूचना दें। Thereafter, kindly come to Exhibit E. Exhibit E.
Yes, what is this?
Exhibit E is a new proposal form which has been signed by the insured.
Then
That is dated as per my report is on 20th of 19th of December 2012.
by paying a much lesser amount.
Yes, 3,000 and something like that.
Paying a much lesser amount.
Lesser amount. Because if one has paid the premium for obtained the policy, then one cannot go beyond again and say that no, you again paid the premium. Why? What? Because he had not objected at any point of time of getting a fresh proposal or getting a fresh policy. Therefore, the owner is developing his case that he was not aware of it. The conduct and the situation clearly shows.
You first let this court understand that owner was made aware of
It was the amount was returned.
Show me that he has received the amount. When he has received.
But that document I do not have. That document I do not have. Then I have nothing to say. If my word is technical, then I have nothing to say. Because in this case,
because you have relied upon Exhibit D.
Exhibit D,
D says.
Exhibit D and Exhibit E.
Exhibit D says.
Exhibit D and E. These are the documents.
Red, which is Exhibit D, which is all the what is that?
Exhibit D is the letter to the insurance company, to the agent for returning the premium and to the insured owner because the premium has wrongly been charged. To which the owner very happily accepted and gave a fresh proposal on 19th of December. So, date of accident is a day before that.
Listen, what he is saying, that I didn't receive all this amount. Once the accident has taken place, I go to the office, then I could come to know. Whatever I had to, the second proposal was made.
No, but in this case, where is suppose the accident has taken place, that it was his duty to inform the insurance company.
He says that on informing the insurance company, I come to know that my this proposal was cancelled.
But everything is beyond imagination. Everything he is saying, because he has not.
Everything what he is saying is beyond imagination, and what you say everything
No,
is.
what is saying? I am supported by the document. My
Yes,
is supported by
very
the
well,
document.
very well.
But
He says, you say that he.
you know, he is a very simple man. He does not know
Listen
everything.
to me, no. You are white as a snow.
No.
Listen to me. He says, you say that we have cancelled it, and he had knowledge of the said cancellation, so he had come for renewal.
Yes.
If that be so, he would have come on 27/11/2002. This, your submission clearly suggests that this cancellation was not conveyed to him.
I cannot improve the case which is beyond my document. The owner and the claimants, they have the capacity to improve their case. But I am putting a question to myself: what was the reason for him to coming up before the court insurance company and offer a fresh proposal? Why he has not objected to it? Why came before? Because he has not appeared before the court below, nor examined any witness, nor examined cross-examined any of our witnesses, nor has cross-examined any of our witnesses.
Whatever you say, I am discarding whatever you say. On your submission.
Yes.
Show me this cancellation was communicated to
Communicated.
The amount was
My
required.
submission, because whatever in the record, I cannot improve this thing. The
There
matter
is nothing
was,
on record to show that it was
it
communicated.
was communicated to the insured by the agent who has calculated the premium.
No, show me that agent has communicated.
There is no such, I don't have any such document. But
Agent is your agent.
agent is my agent, but the agent, as we know, that he is a.
What is the law of agency? What is the law? What is the duty of an agent? Principal and agent. Once there is an agent, there is to be a principal.
Principal,
The agent acts in accordance with the principal.
Yes, if the agent is considered not principal, will be liable.
Will be liable.
That is the settled law. I am not known.
Now act of an agent will be.
But in this case, my contention would be that in this case, the owner has not come up that I was not intimated with regard to the cancellation. Thereafter, why the question will arise, again I have put a question to myself, the question will arise when their policy was in substance, was in existence, which he knew about it. Then why he came before the insurance company and offered to give a separate proposal? Why he gave? Because of course something may not be, everything may not be coming up, but from the circumstances the evidence can be collected, the situation will be collected. Why he has come? Because he was fully aware that he has taken a proposal, he has signed a proposal, he has taken an insurance policy on 23rd 11/2002, which he knew will be effective till 22/11/2003. Then no prudent man will come and say, no, I am signing a fresh proposal. Why, even if the insurance company was pressing hard upon him to sign a proposal, he has not objected to it, nor he has examined any other witness in this regard. So therefore the normal principle will not be the circumstances which could be deduced from the conduct of the owner, that he was fully aware of the cancellation of the policy. That he is not coming up.
When? You tell me when. When he's not coming up.
Because the thing
You
is,
should say when.
on 25/11, because as per my sense, because the day when the letter was sent to the agent.
Agent is your agent.
But it was for the agent to.
See, if the agent is your agent, you have given this document to your agent, that means you have given it to you, and you are keeping it, you sat over.
Let me.
Show me about the provision of cancellation of policy. Yes, Mr. Lal, got it.
Good, thank you. Somewhere in the IRDA regulation policy,
Nothing insurance.
no, but this the IRDA is there in the guidelines.
It's similar type of fish. It's the numbers are.
There is one provision for execution. Then comes some other नहीं अभी नहीं कोई कर पा रहे नहीं देखो I'll assist your lordship. I'm not running away. I'm not running away. 64 BD, subsection 4 we currently DC for BD. But 64 BD, that is the insurance.
Insurance Act.
Insurance.
64 BD, yes.
There is a provision for cancellation, it says for cancellation, but what is the exact provision for cancellation? I will have to check it out.
64
BD subsection 3, the refund of premium which may become due to the insurer on account of cancellation of the policy or alteration in terms of condition or otherwise shall be paid to the insurer directly to the insured by cross order or check by postal money order, and a proper receipt be obtained by the insurer from the insured. Such refund shall not in case be credited to the account of the agent. So it was not given, it was not in the account of the agent.
What do you mean by account of agents? What do you mean by account of agents?
It should not go to the account of agent.
Money should not go to the agent. It should that means it should directly go to the
insured.
Has this amount directly gone to the insured?
But I do not know whether it was in check or cash. That is not
What do you say?
had it been by check, then
For you to say,
well, I'll find it out. You have to, because there is nothing on, I cannot, that is what I am very quickly I am submitting on, that from this record I cannot improve my case because the only thing is that the amount was paid to the agent through whom the check premium was collected to refund this amount, and thereafter the owner insured was fully conscious that his previous policy and cover has been cancelled. Therefore, he came to the insurance company and gave a fresh proposal, and new policy was issued. No prudent man, he never objected to it for the issuance of a fresh proposal or whatever it may be. So therefore, this is sufficient indication to show that he was within the knowledge. Now he is taking a shelter of some of the latches maybe on the part of the insurance company, which he cannot be permitted to take. Because he has not appeared before the court below, only after filing the written statement, he ran away, not examined any of our witnesses, not adduced any evidence that he was not aware of it. For the first time he is coming before this honorable court and saying that he is not aware of it, then he is not able to explain why he should have signed a fresh proposal on 20th.
there is a missing link in your evidence. There is a missing link in your
But the thing is that
evidence.
there is a missing link, but in this case, it is also
That is vital.
But the thing is that is the claimant owner is establishing that he was not aware of it. Then what I have asked that this is my contention before launching.
Suppose he is saying nothing. It is your case. It is your case that we have cancelled. Just listen to me, Mr. Lawrence. It is your case that we have cancelled. Exhibit E, the document. ABC, C is the document. C we have cancelled. Now, it is your case we have refunded. It is your case you have refunded.
Yes.
Show me the document that we have refunded.
That is
showing exhibit E.
Exhibit
D.
D.
D is the cancellation. E exhibit D.
Exhibit
D
D.
doesn't show that it was refunded to this owner.
The
to the
only
agent.
it shows only that it was given to the
The agent.
for refund. Now,
Agent.
had it been the case, hadn't been the case that the owner, after this exhibit D, would not have come to the court, then certainly he had a good case that I was not aware of. Therefore, the insurance company can be solely be held liable. But here in this case, this is my submission, my contention before Lordship. It is up to your Lordship to accept it, not to accept it. But what was the occasion that he came before the court, the insurance company, and signed a fresh proposal and paid the premium? He never objected to it. It was not that he was called upon, but he voluntarily came to us and paid the premium. Subsequent to the amount was returned. And these documents, no witness was examined. He has not examined any of the witnesses, nor he has adduced any evidence that he was not aware of it. So the situation situation clearly shows that he was fully aware of the cancellation of the cover note. Thereafter, he came before the insurance company and signed the proposal. Had it been the case that he would have not have come, then perhaps he had a better case. He had a better case. Now, all these things have been discussed from paragraph 39 to 45 of the award. They are very elaborate and very clearly everything has been discussed threadbare. And previously there was one appeal by the insurance company against the interim award, which was decided by a lordship, and the insurance company was directed to pay, but we have paid 27.
That is an interim.
That is interim, against the interim, against the interim. That was against the interim. Getting the write-ups, but I am not able to get a set provision at the moment. Write-ups are there, the policy can be cancelled. Which provision at the moment I am not able to get.
Come to 147A. What does it mean?
Insurance Act.
No, no, what is it?
Notwithstanding any rule, five, please. 147.5. Notwithstanding anything contained in any law for the time being in force.
26.
Or perhaps by now is looking to the new book which has not come into existence about 20 edition or we are here with
Purana.
Full 94.
Right. Show me up.
This
Should be 4. Should be 4. The fourth portion.
Four. Where the cover note is issued by the insurer under the provision of this chapter or use made thereunder shall not be followed by a policy insurance within the
Is not followed.
is not followed by a policy of insurance. So here in this case, the policy of insurance was never issued.
Read that.
Policy of insurance within the prescribed time, the insurer shall within 7 days of the expiry of the period of the validity of the cover note notify the fact to the registering authority in whose record the vehicle to which the cover note relates to has been registered or such authority or the state government has been prescribed.
Have you applied this?
As per my record, I have not produced any evidence on this point. I have not produced any evidence on this. The cover note once issued remains valid for 60 days. And in between, the policy can be cancelled.
Then information has to be given to the authority.
Wait, that's let me see the exhibits we have filed.
And on what ground the policy can be or the cover note can be cancelled?
But that I was trying to look out.
Because
That I was trying to look out in the provision. Because
should be, there must be some provision.
that was
Not
under
at all.
64. 64 DP is only then
Safe amount.
64 DP is with regard to the 64 DP. Because it speaks about the cancellation and the refund of the premium.
Yes.
Any refund of premium that is directly to be made to the insured and not to the account of the agent. But here in this case, there is no evidence of fine that whether it was the check or cash or whatever or the draft. Because the amount was given to the agent, thereafter the insured came up and obtained the fresh proposal. Again, a fresh proposal and policy was therefore, it is not the case that he was not aware of the cancellation. He was fully aware of the cancellation and he has purchased the policy. Had it been the case that he has not taken any fresh proposal or offered a proposal, then the matter would have been different, entire liability would have been shifted upon me and we would have had no say. But here in this case, the situation makes it different. His conduct is also to be seen. There may be errors on our part, but all our errors have been made.
Mr. Lal, you get various judgments which says that
We continue.
if a insurance premium, the check of the insurance premium gets dishonored,
That is true, but
dishonored but
Dula and the others are there. Dula and others are there.
the fact, the communication of such dishonor is made after the date of the
After
accident.
the accident, then insurance company will be held liable. But here,
So what is the crux? What is the pivot? Communication. And what
communication. But here in this case,
So in this case, you have to show that you have made
no,
the
but the thing is that now, maybe it is the communication is the missing part. But in this case,
the main part.
that is, I am coming to that. Communication is there, but the communication part has been waived by the insured owner by signing a fresh proposal. So that might have been taken that it was not a but that may be unacceptable, but the conduct shows
That communication part, if you say that, then the next question will be, what is the date it was communicated or it came to his knowledge? Then, if you say, then there will be presumption of the date he is signing that he came to knowledge.
But
If you say any other date, you have to prove.
But this amount was given to the insured agent or insurance company agent on 25/11/2000. Thereafter, on 20th of December, the owner signed a trust proposal, the policy was issued. Now, had it been the case that owner had taken a plea that no, I was not aware of this cancellation, the matter would have been certainly different. But here in this case, consciously he was knowing about the cancellation of the policy. He signed a fresh proposal, paid the money and got the policy issued from that date, not from the retrospective date.
No, I understand what you are trying to
Because
say.
this is my contention and beyond that I cannot give too much. And all these things have been discussed in paragraph 39 to 45 of the
Is that okay?
That is what we are. I cannot give you.
Apply. My lord, in this case, some amount has been deposited by the opponent.
Serial number 38, MA number 95 of 50, Mr. DC Gold for Appellant, Mr. D.K. Dhanjal for Respondent.
Yes.
Earlier heard on 14/3
What was the issue?
issue, my lord, the
The right to recovery.
right of recovery has already been given to me, subject to right of from the owner, for which the insurance company shall have the opportunity to sue the owner and get the
If
same.
at all there is no valid existing insurance policy.
Well,
Now the court has to decide whether there is an existing policy or not.
yes.
Court has not decided.
But-
What is the issue?
Issue is, my lord,
Number 9, Lord.
whether there exists a valid insurance policy. Where is the finding? Where is the finding on issue number 9?
My lord, the case is this. Now the validity of valid insurance policy. The policy was cancelled only on the ground that the vehicle was an old vehicle, 1974
Same as
model.
Mr.
जी. So now the of course मतलब right of recovery has given to me, but if on that issue,
When was the
मतलब
policy cancelled?
the date of accident is 27/1/2002. Then the insurance policy cancelled on 23/1/2002 by issuing a letter, Exhibit A, and just after 4 days of the cancellation, the accident has taken place. The fact,
No,
money.
I'm not on that. Your case is different. Just tell me the insurance report, the tribunal has granted you the right to recover the amount, subject to
Proof, money.
whether the insurance policy was valid on the date of accident or not.
G.
So now, for that, if you comply the order of the tribunal, that means you have to first again file a claim, even file an application.
Of course.
With what prayer? With prayer to
But Malad, the fact is,
seeking refund on the ground that the insurance policy was not valid.
valid.
Now, one of the issue in that suit would be whether the insurance policy was valid or not.
G.
Can that be a subject matter of a separate suit or the instant suit?
Of
This
course,
issue
Malad,
number 9.
this should have
Issue number 9.
been this should have been settled in the same proceeding. Of course.
So, issue
But-
where is the
Malad, I'm facing one problem personally, because the ground I must submit before my lord, the ground of cancellation, that is not tenable under. That is what I am facing as an appellant. Of course, right of recovery is in my favor.
You are facing the ground of cancellation is
That is, my lord, on the ground of an older vehicle, 26 years.
26.
Years. The age of the vehicle was 26 years. On that score, the policy was
third party.
cancelled. Third party.
Third party you have to, even if it is 26 years or 42 years.
Yes.
If it is 26 years, if it is more than
Well,
20 years, the comprehensive policy,
comprehensive own damage policy I can deny, but a third
third
party
party cannot deny.
cannot deny. That is the basic
Third
problem.
parties cannot deny.
But without submitting that, I cannot. This is the problem with me. And on the other hand, the right of recovery has given to me, that is in my favor. Of and in one place of the
Read
award,
para five.
my
Read
lord,
para five.
para 5. It is important to mention, while filing the show cause under section 140 of the MB Act, Insurance Act had not denied the fact of insurance, and general objections were taken by the insurance company. At para 10 of the show cause, it was also that if the insurance is found to be correct, then the liability shall be of the insurance company. On behalf of the claimant, 2 witnesses has been examined, namely Suman Linda and Parangat Gari. Suman Linda is one of the claimant, and she said about the occurrence, about the death of her brother. She has stood a FIR such and such, they are after the income, then para 8. Of course, my lord, owner was not present before the court below. OP number 1 was the owner of the vehicle. 8. On behalf of OP number 2, one witness has come up, named S.N. Singh, who is senior divisional manager. He has stated that power note number such and such was cancelled on the next day, and the owner as well as the financer as well as DTO was informed in this regard. He categorically said that the premium was not taken by the insurance company, and as such there was no existing insurance policy. On the date of occurrence, cross-examination, this witness says that the cancellation letter was sent to the owner. He said that the power note showed validity from such and such, and apart that there is nothing significant in this cross-examination. My letter of cancellation is Exhibit A, and Exhibit 1 is the copy of the then detailed discussion regarding age of the vehicle, page 6. The court has said that I have not produced the cancelled policy or the power note. I have only produced the letter, Exhibit A. Therefore, liability has been given to me, the initial liability.
See,
Well,
on page 16.
16, last.
Yes.
Well,
Under such circumstances, read this.
100%.
Read this.
Under such circumstances, it appears that insurance company has not been able to prove beyond all shadows of reasonable doubt that the power note issued on 22/1/2002 was cancelled on 23/1, and therefore at this stage.
Now, when the court comes to a conclusion that you have failed to prove this, now where?
Yes,
Then
sir.
again file a suit to contest the same.
Therefore, my lord, for the sake of argument, if this appeal is dismissed, then perhaps the appellant will be in a better place.
You are right. You are absolutely right. If the appeal is dismissed, then the appellant will be at a better position. Who are you?
And you are also claimants.
If you withdraw, I will be in a better position. If I have to give a judgment, I have to give this.
Regarding withdrawal, my lord,
If I have to give an order, I have to come to the appellant. I have to quote that.
my lord, certainly,
If you withdraw, it will be better.